The Young Offenders Act, or the YOA, was brought in as a response to the JDA, and the goal was to address those issues of not being strict enough. So they wanted to hold youth responsible in order to protect society. But they also tried to carry over some principles of the JDA, including that youth have unique needs that are distinct from the needs of adults, need to think more about treatment and rehabilitation. And also there was the belief that youth were more capable of being rehabilitated than adults. So there was some emphasis on how we should try and find community-based solutions to keep youth out of custody. Now, this was an emphasis of the YOA. This was a goal of the YOA, but it completely failed. To address the issues with violating youth rights, the YOA became much more focused on procedural rights, looking at legal rights and freedoms of the young person and making sure that these were maintained through all stages of the court process. One of the main concerns was proportionality in sentencing. And so this is where we began to see the dissolving of indeterminate sentences and the establishment of case law so that judges would be bound by certain past cases when handing down a particular sentence. What I have just discussed basically illustrates that the YOA was trying to emphasize a lot of things, and sometimes things that were in conflict with one another, things that weren't really in agreement. How do we emphasize protection of society and holding youth responsible, which were more kind of like crime control measures or punishing of youth, while also trying to say that we need community-based solutions? So on the one hand, some sections of the YOA are saying, hey, keep youth out of custody. On the other hand, other sections of the YOA are saying, hey, you need to punish youth and put them in custody in order to protect society. And so judges are kind of being given these discrepant principles and aren't really sure which one to prioritize. And so we're going to see some key issues with the YOA that resulted from this lack of hierarchy in principles or goals. On that note, some of the key goals of the YOA were, again, to hold young people more accountable, to provide greater protection to society, so protecting society from these young persons, and the need to minimize the impact of the justice system on young people, so thinking about labeling theories and how a young person's involvement in the justice system could further contribute to their continued offending. This was very much in line with the notion of state-dependent effects, which is if we, for example, incarcerate a young person, maybe that separates them from school, separates them from family or pro-social connections in the community. And when these bonds are severed, when they are released from custody, maybe they are going to be more likely to associate with delinquent peers rather than pro-social peer groups. Or now that they're out of school, they don't really feel connected to school or connected to teachers, so maybe they'll become more prone to skipping school or dropping out of school altogether. The YOA also wanted to protect the legal rights of the young person. So while they wanted to become more punitive, also wanted to make sure that the youth justice system looked like the adult justice system. And youth were always going to be represented by lawyers. One of the collateral consequences of trying to make the youth justice system look more like the adult justice system was that youth then became treated more like adults, meaning that they were punished more severely than they may have been punished in the past. Canada's general public began to look at youth not as young persons who had the capacity for rehabilitation, but rather serious and violent youth who were going to become tomorrow's serious and violent adults. So by making the youth justice system more formalized, it gave the public kind of this impression that, oh, these youth must therefore be very, very serious offenders, even if that might not have been the case. Is the judge supposed to focus on the rehabilitative needs of the youth, or protection of the public, or procedural justice? And so different judges could elect different principles or different goals depending on their own personal preferences or what they thought the personal preference of their employer was, aka the government. There were some major differences between the YOA and the JDA. One of them was that the minimum age of criminal responsibility was raised from 8 to age 12. They specified under the YOA maximum sentences, so they abolished indeterminate sentences. Under the YOA, they also established alternative measures. This was a way of trying to keep youth out of the formal justice system so they did not experience those labeling effects. So this meant diverting youth, keeping them out of the formal justice system, and using these more community-based responses to youth crime. Under the YOA, there was a recognition that the young person should not be punished for status offenses, because this was essentially a charter violation. Essentially, it's kind of like cruel and unusual punishment. Youth are thought to be less responsible for their behavior compared to adults. So why is the justice system punishing youth for a behavior that an adult wouldn't even get punished for at all, let alone a less serious form of punishment? The JDA lasted for almost 80 years. The YOA didn't even last for 20 years. Response to the issues with the YOA underwent 3 major amendments. The first amendment was focusing on procedural changes. So you don't need to memorize all of these changes. You just need to understand the general theme here was procedural changes. The second and the third amendments to the YOA focused on getting tougher on crime, raising the maximum sentences for first and second degree murder, creating parole for youth transferred to adult court so that youth would actually be monitored upon release from adult court, as opposed to in the past, youth would just finish their custody sentence and they would have no form of community supervision. So for youth committing serious offenses that have been transferred to adult court, once they're released, they are now under parole supervision requirements. As I mentioned in the past, there was that sort of discretionary issue with judges. Do they focus on rehabilitation or protection of the public? The Second Amendment said you absolutely focus on protection of the public when making decisions during transfer hearings. So if a youth was to be transferred to adult court, basically it would be because their offense was serious and they thought that the youth needed to be dealt with in the adult system where the punishment could be more severe so that the protection of the public could be accomplished. I'm not saying that that was actually successful as a way of protecting the public, but that was the thinking at the time. The third wave of amendments was again about getting even more tough on crime. The YOA further raised the maximum sentence for first-degree murder and second-degree murder. 16 and 17-year-olds involved in serious personal offenses would be automatically tried in adult court, and that reverse onus again was there, where the youth had to show on a balance of probabilities why the protection of the public would be better served if they were dealt with in youth court. And then victim impact statements were introduced to allow persons, not just the victim of the offense, but their family, to describe to the court how the offense negatively impacted themselves as a way to act as an aggravating circumstance against the young offender during their sentencing. Basically, this third wave of amendments was trying to increase sentence lengths and increase the feasibility or the ease at which youth were transferred to adult court. When I mentioned that they raised the maximum sentences, this was the maximum sentence if the youth was being processed under the Young Offenders Act. If the youth was transferred to adult court, then those 10 and 7-year maximum sentences went out the window and they could be given a life sentence, just like any person who was an adult. So even after these amendments, judges complained and law and order advocates complained of the lack of a hierarchy in the guiding principles. Do judges focus on rehabilitation and understanding that youth should be held less accountable, or should they be punished more severely? One of the continued criticisms of the YOA was that youth crime rates were on the rise. So some people believe that this was evidence that we needed to get tougher on crime. The reality, however, was that the increase in crime rates was actually probably more a product of getting tougher on crime in the first place. The getting tough on crime approach meant that the justice system was now casting a wider net. More young persons were being brought into the justice system. In Ontario, for example, in the late to mid-1990s, they instituted zero tolerance policies at school. Hey, teacher, leave them kids alone. So a fight at school would automatically result in a suspension, but also police were told to automatically arrest that young person. So in the past, these minor fights at school would go unpunished, but now that they're being formally prosecuted, or at least they're formally being arrested,